Hey, what's up, guys? This is AJ. Uh, See, we in this lecture series, what we do is that I will dictate some points. You will listen to those points. You will make notes out of those points, and you will revise those notes. Okay. So, as there is a scarcity of time, so we are adopted this kind of approach. Okay. So, I hope you will like it. Okay. The quality of the video will be dumb, but the quality of the content will be good. Okay. That is my promise. Okay. So let's start. Today's topic is National Court of Appeal. See, in 2010, K.K. Venugopal, uh, okay, so he was the justice, judge. So in Jain Memorial, he gave one lecture, and he proposed this kind of idea. What? National Court of Appeal. Okay, so what was the idea? So idea means instead of adding more members to Supreme Court, he wanted to create 4 regional or zonal courts of appeal. Okay, so right now, what is the situation currently is that there is only one bench of Supreme Court. Okay, Supreme Court sits only in Delhi. So everybody, what happens that we know the cases are so many cases are pending in the Supreme Court as well as in other high courts. Okay, so what have people has to travel from their respected village and go to the Delhi. Then they have to live there. Then they have to pay the fees to the lawyer. Then they have to see if they want to submit something, they have to took some xerox. Okay, they have to spend some money on lodging purposes, they have to spend some money on uh, lunch, dinner. These kind of all kinds of expenses are there. So it is getting justice is very expensive. Okay, so to avoid this, what the Venugopal suggested that we should create one zonal Supreme Court, like courts which are going to deal with particular types of cases. Okay, so yes, we know that there are high courts are there, but still the questions of laws which Supreme Court takes right now, we can divide those types of cases and distribute those types of cases in the regional zonal uh, courts. Okay, so that is the basic idea of National Court of Appeal. Okay, so how many cases are pending in the Supreme Court? Approximately or more than 60,000 cases are pending in the Supreme Court. This statement also you can directly put in your answer. Okay, no need to research on it. Okay, again these what he suggested that these there are like 140 categories of cases are there, and these categories can be transferred to the these regional or zonal courts of appeal. Okay, that is his idea. Then these cases will be like these kinds of cases will be under the exclusive authority of the or the jurisdiction of those National Court of Appeal. Okay, then the judges that we are going to appoint in those kind of zonal courts, their caliber should be as equal as the Supreme Court judge. Okay, that is his one criteria. Again, their retirement age should be 65 years. This is his idea. Then again he proposed one more thing that the article 136 talks about the Supreme Court. Okay, so if you want to create one court which is as equal as Supreme Court, then we need to amend the constitution. So he suggested that we should amend the constitution and add article 136A. Okay, in that A we will introduce this concept of National Court of Appeal. Okay, so again, what is the need of this kind of National Court of Appeal? As I told you earlier that there are 60,000 odd cases pending in the top courts. Then people go through difficulties like physical difficulties, financial difficulties, expenditure on travel, lodging, lawyers, etc. This kind of very expenses they have to bear. Then geographically proximity. Again, what happens if I say you that you will get a justice, but you have to spend so much money and you have to travel for the distance places. Will you go or will you opt for this kind of justice? You will say, instead of getting this kind of justice, you know I will not demand my justice. I will live with the whatever the justice given by the lower courts. Okay, so this is what happens. Then people are losing the faith over the judiciary. Okay, then what happens again? To solve the disputes, they go to the local panchayat or the local landlords, whoever um, the big goon in that particular area. These kind of people solve these kind of disputes. Okay, again, why we introduce justice system, that judiciary system, that is integrated judiciary system, which is part of the unitary feature. Again, I will make one more point, that it is not the point of our discussion, but unitary. If you see integrated word, then this is not a part of a federal structure, it is part of a unitary structure. Just remember that. Okay, integrated word means unitary functions. Okay, so again, what is the problem? Then we introduce judiciary system because so that the poorest of the poor or underprivileged people or the left like weaker sections of this society should get the justice. That is the idea behind introducing this judiciary. But just because judiciary is becoming expensive, unviable, in proximity is not there, they have to travel long distances, people will not opt for this kind of judiciary. They will solve their disputes within themselves. Okay, so there is a fear of not getting justice. Okay, there will not be any fair judgment in those types of cases. Okay, so that is why, to attract more people in the judiciary system, so that they will bring their cases in the judiciary system, we need to easen or lose their burden. Okay, so to do that, this is the idea given by the Venugopal, that National Court of Appeal should be there. Okay, then uh, what he suggests is that, as I told you earlier, that 140 categories of cases. See, we don't need to remember how many categories of cases should this National Court of Appeal get. Okay, so as I told you, that this Venugopal guy is just judge himself, so he knows in-depth knowledge of this particular functioning of the Supreme Court. Okay, so that's why he uses these kind of words. We as an administrator, aspirants, okay, so we don't need to use these kind of terminologies. Okay, so just we can say that there should be segregation of the work, distribution of the work, so that will be the job of the SC as well as job of the National Court of Appeal will be easier. That is the idea that we are going to propose in our answer. Okay, so remember this. Then he said that SC will be then free to examine the cases which are vested in it by the framers of the constitution. See, there was a big idea inside the mind of the framers of the constitution. Okay, so that's why they introduced the concept of Supreme Court. Okay, so these the questions they take, not normally a normal person can answer on these type of questions. These are very philosophical questions, like what is justice, and like what is the current scenario. There is a problem of going right to privacy. Okay, so whether it is a fundamental right or not. So these kind of decisions, they affects almost all of the citizens of India, all the citizens of India, not almost all the citizens of India. So these are very crucial decisions, and these are very difficult also. Okay, so one needs to understand the concept of the privacy. One need to see what are the legal aspects inside this. So these are very difficult questions, and these difficult questions are related to every citizen of India. So to decide on these difficult questions, they introduce the Supreme Court. That is the basic idea in the minds of the framers of the constitution. So that how many members, how many judges are in the Supreme Court? 31. Okay, so 31 judges cannot solve so many cases. So that's why this there is very less number of Supreme Court judge, because not everybody has that kind of caliber, as well as they should discuss the very few cases, but the effects of those cases will be very huge. Okay, that is the idea behind in the minds of the framers of the constitution. But right now this is not getting followed completely. Okay, so what is happening, that they deal with any kind of cases, like we discussed the PIL issue, that in PIL also what happens, that anybody puts any subject under the PIL and demands the Supreme Court's verdict on it. Okay, so Supreme Courts get disturbed. Okay, they cannot focus on their main job. Okay, so that is why this KK Venugopal says that we need to do these kind of things, like separate the work of the Supreme Court, give them the work that was meant to be to them by the framers of the constitution. Okay, that is the idea. Okay, next point, what is the criticism? Okay, last point is criticism. See, the criticism is simple. It will dilute the constitutional superiority of Supreme Court. That is the first. Then there must not be any branches of the Supreme Court. Okay, that is the idea. Why there should not be any branches of the Supreme Court? See what happens again. If like if you are working in a particular company, okay, and if your boss sits right next to you, what will happen? You will have to work dedicatedly. Okay, you have to show some dedication, you have to be sincere, you have to be punctual in your job. Then because you know that boss is always watching you, so what happens? And remember the day when boss is absent. Do you work with that kind of enthusiasm that you were showing earlier? No, you don't. That is the practical thinking. That's why uh, many people argue that if you introduce the new branches of the Supreme Court, what will happen? The CGI cannot overlook or monitor all the branches of the Supreme Court. Okay, so he will have to focus on only the branches, one branch at one time. So what will happen? There might be corruption in the other branches. That is the fear. So that's why there must not be any branches of the Supreme Court. But this what our National Court of Appeal says, that this it's almost like a branch of the Supreme Court. That's why it is introduced under the Article 136. Okay, there is only subdivision is there, 136A. Okay, that is the idea. I'm sure you got this point. Next point is focus to make subordinate judiciary stronger. Again, what is the problem? What happens that if you go to the district court, okay, if a particular appellate goes to the district court and he demands a justice, and if he gets complete justice in the district court only, will he opt for the higher courts? Obviously no. So we need to, instead of creating more courts and recruiting more people with the caliber of the Supreme Court judges, okay, instead of this kind of wasting your power in these kind of things, you should focus on the making the subordinate courts stronger, so that the justice will be delivered in the subordinate courts only. So people will not have to opt for the Supreme Court or the high courts. Okay, that is the idea. That is one criticism. Okay, last point is again so issue of proximity relevant only up to high courts and cannot be extended to the Supreme Court. Again, as I told you earlier, Supreme Court cannot be introduced everywhere, just because these kind of people wants like justice. Okay, so what is the idea? That the Supreme Court should be in the location, only one location throughout India, not only in the Delhi. That is not the idea, but there should be only one bench of the Supreme Court. Okay, so that is the idea given by the some thinkers. Okay, that is, I don't know who gave this idea, but that is the idea there. Okay, so again, last criticism point is don't do these kind of things unless and until there is a dire need presented by the state or the political class. That is one more thing that criticism expert criticize this National Court of Appeal, and they say that we should not introduce this kind of thing unless and until this is presented by the state or the political class. Again, what is the reason? Because we know, as I told you earlier, integrated judiciary is the unitary is a unitary in nature. Okay, so we need to, what we need to do, we need to boost the federal structure. If we introduce this kind of judiciary, it will damage this federal structure. Okay, so we need not we should be very careful introducing in these kind of new things. Okay, so that is the criticism. So thanks guys for watching this video, and we will meet in the next video. Peace.